webinar is hosted by the Faculty of Law and the University of Toronto, a vibrant intellectual community that is home to a diverse range of ideas and approaches. The faculty stature as one of the very best law schools in the world rests on the excellence and diversity of our faculty, robust clinics and centers, and the caliber of our students. Today, University Professor of Law and Philosophy David Dyzenhaus will address Trump, the rule of law, and the rise of illiberal democracy. Professor Dyzenhaus is a Fellow of the Royal Society of Canada. At the University of Toronto, he holds the Albert Abel Chair of Law and was appointed in 2015 to the rank of University Professor. He has taught in South Africa, England, Canada, Singapore, New Zealand, Hungary, Mexico, and all over the United States. He holds a doctorate from Oxford University in law and undergraduate degrees from the University of Witwatersrand, South Africa. In 2002, Professor Dyzenhaus was a Law Foundation Visiting Fellow in the Faculty of Law at University of Auckland. In 2005 to 06, he was a Herbert Smith Visiting Professor in the Cambridge Law Faculty and a Senior Scholar of Pembroke College, Cambridge. In 2014, he was the Arthur Goodhart Visiting Professor in Legal Science in Cambridge. In 2016, he was a Fellow of the Wissenschaftskolleg zu Berlin. And this year, in the 2021 academic year, he will be a Guggenheim Fellow. Professor Dyzenhaus has written numerous books, and in the interest of time, I'll just highlight one of them. He wrote The Hard Cases in Wicked Legal Systems, South African Law in the Perspective of Legal Philosophy. In 2004, he gave the J.C. Smuts Memorial Lectures to the Faculty of Law at Cambridge University. These were subsequently published by Cambridge University Press in 2006 as The Constitution of Law, Legality in a Time of Emergency. He is the editor of the University of Toronto Law Journal and co-editor of the series Cambridge Studies in Constitutional Law. It is my honor to present today's speaker, Professor David Dyzenhaus.
Thank you very much, Albert, and I'm glad that you mentioned the South African connection, because my talk is going to be delivered in a relentlessly South African accent, something I haven't managed to lose in 32 years in Canada. Let me start my talk with a few preparatory remarks. I'm not going to talk much about the current health crisis. I think it's probably a good idea to talk about something else for the time that I have. Although what I am going to be talking about is something that's probably no less depressing, and I will make a couple of allusions to the current crisis during my talk. The idea for this talk came about just after President Trump was elected. And I watched the news clips of first Obama's reaction and then Hillary Clinton's reaction to his election. And both of them had a common theme that they were concerned about. And the theme was what was going to happen to the rule of law under Trump. And at the same time as Trump was elected, there were concerns about the rule of law elsewhere, particularly in countries like Hungary and Poland, in which there also seemed to be a new experiment taking place with democracy, the experiment with illiberal democracy. And because of these events, I decided to teach a course which has the same title as my lecture, Trump, the Rule of Law and the Rise of Illiberal Democracy. I've taught this course twice now to undergraduates, that is first-year undergraduates in arts and science, people straight out of high school. And we go through various issues about the rule of law in this course, because I think it's important for them to know about these issues early on. And we also focus to some extent on the rule of law in Canada. Let me move to my second slide. So this is early in Trump's presidency. And here we have a slide of him nominating Neil Gorsuch to succeed Antonin Scalia. Gorsuch may well be the most conservative judge on the US Supreme Court at the moment. And in view of what's to come, I want to highlight something about this slide. First of all, it is the only slide in which there's a woman, and that's Gorsuch's wife. And secondly, it's the only slide in which there's someone who's not a Catholic, and that is President Trump. Because the rest of my slides, at least the photos, are going to be slides of Catholic men. And there is something interesting here. I need to be a little bit careful about the claim that I want to make. First of all, I'm not going to be making a claim that there's a conspiracy of Catholics, far from it. As you'll see from the text in my slides, what I'm going to be describing to you is all perfectly public. But secondly, the kind of Catholicism I'm going to be alluding to is in no way the Catholicism that is espoused by most Catholics. It's a particular kind of Catholicism, a militant kind of Catholicism that has come to the fore recently. And in the last week, when I was talking to a friend of mine, a very eminent Canadian lawyer who is a devout Catholic, about this phenomenon, he suggested to me that this militant Catholicism might well provoke a schism in the Catholic Church. So in no way do I think that this Catholicism is typical of Catholicism in general. But still, there is something significant in the common Catholicism of the people that I'm going to be talking about, and how their militant form of Catholicism links to populism. Right, third slide. Here is Trump and Victor Orbán, the leader of Hungary, a kind of nominal Catholic. No one really thinks that Orbán has serious religious beliefs. I think he's much like Mussolini, who, as you probably know, was a militant atheist at the beginning of the 20th century. He and his thugs spent their time beating up and assassinating Catholic priests until the point when he made a pact in order to gain power with the Vatican. Orbán, as you know, is the political coiner of the phrase illiberal democracy. And here from 2018, at the top of the slide, we have an extract from a speech that he gave in 2018. The speech is to be found, by the way, on the Hungarian government website. Orbán talking about his victory in 2010, which gave him the majority in parliament that he needed to amend the constitution, says that with that victory, he had brought to an end 2 chaotic decades of transition and was now able to build a new system, a new constitutional order based on national and Christian foundations. And right at the end of the speech, he proclaims his allegiance to this idea of illiberal democracy. He says that liberal democracy sides with adaptable family models, while Christian democracy rests on the foundations of the Christian family model. Once more, this is an illiberal concept. Now, here comes my first allusion to COVID in the talk. The extract that you have at the bottom of the slide is the law of April of this year enacted by the Hungarian parliament, which gives to the government, without any time limit, complete power over legislation. You can't get this just from this extract from, I think, the second provision in the law. But the enactment of this law has been likened by expert commentators to what was called the Enabling Act in Germany in 1933, when Adolf Hitler got a thoroughly cowed parliament to hand him supreme legislative power. Orbán is now in very much the same position as Hitler was in 1933 when it comes to legislation. Right, slide 4, someone who will be familiar to all of you, I think, William Barr, the US Attorney General. As Attorney General, he is supposed to supervise the activities of the Department of Justice in a way that maintains the constitutional independence of that department. Now, as we know in Canada, from recent events, from SNC-Lavalin, whatever the structure one has for the Attorney General of a country, it is actually quite difficult to maintain the constitutional independence of that office. But at least during Barr's tenure of this office, he hasn't seemed at all concerned with maintaining any independence of the chief executive, that is Trump. Rather, all of his actions seem to be subservient to Trump's agenda. Now, Barr, like most of the other people who are going to be appearing in my slideshow, is a Catholic, and he is a militant Catholic, an unabashedly militant Catholic. The first quote that I have is from a speech in 2019 at Notre Dame University, which has the following quotes in it. I think we should do all we can to promote and support authentic Catholic education at all levels. I can assure you that as long as I'm Attorney General, the Department of Justice will be at the forefront of this effort. A very interesting quote, I think, in a context in which there is supposed to be a separation of church and state. And the second quotation that I have from Barr is a quotation from a speech that he gave to the Federalist Society, where he says that the executive in the US Constitution has the power to handle essential sovereign functions, which by their very nature cannot be directed by a pre-existing legal regime, but rather demand speed, secrecy, unity of purpose, and prudent judgment to meet contingent circumstances. And what I want to particularly highlight there is the idea of essential sovereign functions, which by their very nature cannot be directed by a pre-existing legal regime, because there we get the idea, which I'll come back to later, that when it comes to the most important functions of the sovereign, those functions are uncontrolled by law. And I think the important point that I want you to take away from this slide is the link between the claim about militant Catholicism and the claim about the executive. Right, next slide. John Finnis, Emeritus Oxford law professor, one of the leading legal theorists of the last 50 years, the main proponent of the Catholic natural law tradition in legal philosophy. And I think the most influential legal theorist since World War II. Just one mark of his influence is, if I flip back to my first picture, the picture of Trump and Gorsuch. Gorsuch is a student of Finnis. He did his PhD with Finnis. Finnis has managed to place people in powerful positions throughout the world, including, I should mention, on the Ontario Court of Appeal. It's not the case that every person who's supervised by Finnis is a disciple of John Finnis. Let me mention two people. One is the present Dean of Queen's Law School, Mark Walters, who did his doctorate with Finnis and is in no way a disciple. And the other person is the person who's speaking to you. Finnis was one of my supervisors in Oxford, and I had a very fruitful time with him as supervisor, but don't regard myself as in any way his disciple. But nevertheless, there are a bunch of people around the world that Finnis has managed to place in very powerful positions. But the major impact that Finnis has had in the last few years has been through a project that he established, which is called the Judicial Power Project. And here you have a slide from the Judicial Power Project, which features an article, I think, by Finnis on the unconstitutionality of the Supreme Court's prorogation judgment, something I'll talk about in a minute. The Judicial Power Project was established some years ago, and its main aim at the time that it was established, on a website which is very well funded and which refuses to reveal the sources of its funding, its main aim was to contest the human rights jurisprudence that UK courts had been developing under the European Convention on Human Rights and in the wake of the Human Rights Act of 1998, which incorporated many of the rights in the European Convention of Human Rights directly into English law. And the point of the Judicial Power Project was to argue that judges had usurped power through this interpretive function that they have under the European Convention of Human Rights and the UK Statute on Human Rights, which seemed rather odd, because the claim was that the judges were undermining the sovereignty of Parliament. Yet, as I'm sure you all know, English judges have no authority to invalidate statutes. Their authority is limited to interpreting the limits on executive action under the rule of law. When the Brexit saga started, the policy of the Judicial Power Project changed, And the lawyers who, for the most part, write on for this judicial power project started to provide the legal arguments for the government to exit the European Union, and in particular to provide the arguments for the way that the executive could exit the European Union without parliamentary sanction. And this is again something I found quite odd, because the whole justification of the judicial power project was to preserve and restore parliamentary sovereignty. But in the last couple of years, the arguments made by the lawyers whose pieces appear on the Judicial Power Project website have really been about putting in place the sovereignty of the executive over Parliament. And Finis has been particularly prominent in putting forward these arguments. The next slide, we have two quotes from Finis. And I think one can make the same kind of link between these quotes as I suggested to you we might make with the quotations in the slide from William Barr. Let me just pause, because I suddenly remembered, and I apologize for this, that right at the beginning of my talk, I was supposed to tell you that if you do have questions for me, and there will be a question and answer period at the end, you should use the question and answer function on the Zoom site. And those collections will be collected by Raquel, who's managing this webinar, and she will read them to me at the end, and I will attempt to answer them. Okay, back to Finis. So here we have the two quotations, one from an article in 2009, Finis talking about what he regards as the Muslim threat in the United Kingdom, Muslim population increasing rapidly by migration, relatively high birth rate. People observing this, he says, should ask themselves whether it is prudent to permit any further migratory increase, or even, and this is the highlighted bit, to accept the presence of immigrant non-citizen Muslims without deliberating seriously about a possible reversal, humane and financially compensated for and incentivized of the inflow. Now, what does a possible reversal of the inflow mean? I think what it means is something like ethnic cleansing. That is, getting rid of those Muslims who don't have a right as citizens to be in the United Kingdom. It's couched in rather euphemistic terms, humane and financially compensated for and incentivized, a possible reversal, but that really is a call to get rid of a significant portion of the population. And the second quotation I have is from a piece that he wrote this year during the Brexit saga, where he says that the legal and democratic principles of our constitution now point to one resolution of the EU withdrawal crisis, prorogation of Parliament for 2 or 3 weeks, so that ministers can settle down to exercising their abundant statutory and prerogative powers to prepare for the immediate consequences of a no-deal withdrawal. Here you can see that it was Finis who came up with the idea that in order for the government to get rid of parliamentary supervision of the Brexit process, should simply prorogue Parliament at the crucial time, so that Parliament was unable to provide its supervisory function. And again, we get an interesting conjunction between an idea which of a certain kind of polity, where people who are regarded as alien and dangerous are expelled, and the thought that in order to achieve this end, what one should do is give the executive a particular place in the constitutional order. Right, next slide. And again, a rather grumpy looking fellow. I must confess that when I looked for slides for my talk, I did look for more grumpy photographs. But this is Adrian Vermeulen, a Harvard law professor, one of the leading constitutional lawyers in the United States of America, and like Finis, a converted Catholic. And here we have some quotes from Vermeulen. A quote from 2019 in an online Catholic journal. We are waiting for a universal church that draws upon the pattern and model of all its diverse saints and ancestors, and identifies as necessary the spirit of Paul, the strategic Christian, the kind of Christian that I've been referring to as a militant Catholic. And then from a very recent article, which caused a lot of controversy in the Atlantic, where Vermeulen sets out his vision of constitutionalism, he says in that article that one can imagine, and this is actually his emphasis, which I've re-emphasized, one can imagine an illiberal legalism that is not conservative at all, insofar as standard conservatism is content to play defensively within the procedural rules of the liberal order. Now, the idea of illiberal legalism that Vermeulen himself highlights is an idea that clearly riffs off Orbán's understanding of illiberal democracy. And the point of illiberal legalism, as I see it, is to use the law as an instrument in order to put in place something that we would call illiberal democracy. That is a democracy that's not based on the formal equality of all who happen to be within a territory, but a democracy in which one vision of the people, that is a nationalistic religious vision, is the basis for the political order. And so, as Vermeulen says there, he is rejecting what he calls a standard conservatism. What's wrong with standard conservatism? It's content, as he says, to play defensively within the procedural rules of the liberal order. And I think what Vermeulen is suggesting in this piece is that the constitutional rules that both conservatives and liberals have taken for granted in the United States for centuries are no longer the rules that should limit what a certain kind of conservative should do in trying to promote their vision of what's right. Even more controversially, the last quote on the slide, this comes from a tweet that Vermeulen put out some months ago when there was going to be a conference of conservatives opposed to Trump at Harvard. The entirety of the tweet is what you see at the bottom of the screen there, the very first group for the camps. This tweet caused even more controversy than the piece about illiberal legalism. Vermeulen eventually removed himself from Twitter because of the storm that followed this tweet. But nevertheless, I think that there is an interesting resonance in that tweet with the other ideas that one can see in these short extracts from things that he said over the last couple of years. I thought that I shouldn't neglect Canada in my talk, so for this, I had to go back to the 1950s, to the Premier of Quebec, Maurice Duplessis. And it's significant that at the time that he's giving this speech in the 1950s, he was not only Premier, but also Attorney General of Quebec. And if one thinks there's a constitutional problem generally with maintaining the independence and impartiality of the Attorney General in Canada or in the United States of America, where William Barr seems to be doing the bidding of Trump, I think those problems pale in comparison to the problem that was created in the 1950s in Quebec, when Duplessis was both Premier and Attorney General of Quebec. And what I want to talk about now for just a few minutes is a case with which I think you'll all be familiar, perhaps one of the most famous Canadian cases of all time, and that is Roncarelli and Duplessis. Now, as you'll recall, this case arose because of the missionary activities of Jehovah's Witnesses in the 1950s, and actually earlier as well, in Quebec. And Duplessis, who, while he had his own problems with the Catholic Church, thought that Quebec society was under threat if one's understanding of Quebec society was that the authentic Quebec society is a society composed of Francophone Catholics, because the Jehovah's Witnesses were particularly intent on converting Catholics to their religion. Because of the activity of the Jehovah's Witnesses in towns in Quebec as well as in Montreal, there were large-scale arrests of Jehovah's Witnesses, and Roncarelli, you'll recall, was a very successful restaurant owner in Montreal who stood bail for the arrested Jehovah's Witnesses, who would immediately get back on the streets and continue with their missionary activities. Du Plessis was very exercised by Roncarelli's activity and contrived it that the liquor commissioner of Quebec annulled Roncarelli's liquor license, which caused him to go bankrupt. And Du Plessis was quite blatant about his motives for doing so. He wanted to get rid of Roncarelli, and he, in his capacity as Attorney General, did his best to prevent Roncarelli from getting any legal recourse for the stripping of his liquor license. Roncarelli eventually ends up in the Supreme Court in 1959, and the majority of the court finds that Du Plessis acted beyond the limits of his authority in taking away Roncarelli's liquor license. And here we have one of the great quotes from the judgment, the judge of Rand J, who has the leading judgment in that case, where Rand says that an administration according to law is to be superseded by action dictated by and according to the arbitrary likes and dislikes and irrelevant purposes of public officers acting beyond their duty. If that's the case, what we would have is signalizing the beginning of the disintegration of the rule of law as a fundamental postulate of our constitutional structure. I think this is one of the great short quotations about the rule of law that one will find in a judgment anywhere. But there is a problem that I want to point you to in this quote, and that is Rand's reference to the arbitrary likes, dislikes, and irrelevant purposes of public officers acting beyond their duty. Now, it's true in a certain sense, and he was keen to emphasize this in his judgment, that if one thought that the point of the Liquor Act in Quebec was to regulate liquor sales, that standing bail for your fellow Jehovah's Witnesses had nothing to do with improper use of your liquor license. But Du Plessis did not regard his action as arbitrary. He regarded his action as required by the need to uphold his understanding of the identity of the Quebec people, which he thought to be threatened by the Jehovah's Witnesses. And so we get the one element that I've pointed you to in other slides before, this idea of a substantive understanding of the people that has to be maintained by those who are in charge of the law. And the legal problem arises, as one can see in the next slide, in one of the dissenting judgments, is a judgment by Cartwright in the Roncarelli matter. The statute in the matter, the Liquor Act of Quebec, said that the liquor commissioner would deal with licenses at his discretion. That's all it said when it came to liquor licenses. And Cartwright dissenting says, in the case at bar, on the contrary, compared to other statutes, no standards or conditions are indicated, and I'm forced to conclude that the legislature intended the commission to be a law unto itself. And what we get here, I think, is an example of a judge understanding the law being used to place executive officials beyond the law. And that creates a legal problem that I think is very difficult to deal with, something I'll come back to a little bit later. Right, my next slide is a slide which depicts Carl Schmitt, a conservative German lawyer, very prominent during the Weimar period and during the Nazi period, sitting with one of his friends. And I confess I put the friend in just because the friend is wearing a German military uniform. But that's to point out that after 1933, Schmitt did join the Nazi Party, became one of the principal legal advisors to the Nazis. But it's important to keep in mind in trying to understand Schmitt that before 1933, he was not a Nazi. He was a conservative very prominent academic lawyer who was deeply opposed to the Nazis, and indeed was one of the advisors to the federal cabinets of the early 1930s, which was trying to keep Hitler out of power. Nevertheless, after 1933, once Hitler has won power, Schmidt did join up quite enthusiastically with the Nazis, but didn't manage to remain in their power, in their favor for very long. After the war, because of his involvement with the Nazis, he was not allowed to teach, but he maintained a very effective influence on German public law and on German thinking, despite the fact that he wasn't allowed to teach. And he's risen to prominence in North America and elsewhere in the last few years. I should mention that Adrian Vermeulen, the constitutional lawyer whose photo I had up earlier, is a declared disciple of Carl Schmitt. But if one looks at the mainstream media, if one does a Google search for Schmitt, you will find that he's referred to all the time as someone who is helpful if one wants to understand the way things are developing in our world. And what I have on this slide is just a few quotes from works of Schmitt in the 1920s and early 1930s. The first quote is from his book called Political Theology in 1922, where Schmitt says, "Sovereign is he who decides on the exception." And the idea here is that we will find out who the political sovereign is in moments where of constitutional crisis. And if we go back to the Barr quotation about the executive, I think one finds the very same idea as one finds in Schmitt. That is the idea that when it comes to moments of exception, the legal order does not constrain what the executive does. The second quote is from perhaps Schmitt's most famous book, The Concept of the Political, 1932, which starts with the sentence, "The concept of the state presupposes the concept of the political." And shortly thereafter, Schmitt says that the specific political distinction is that between friend and enemy. And the idea here is that a political community is composed of friends, and the way that a political community maintains itself is by excluding enemies. And what is the basis of a political community? For Schmitt, the basis of political community is an idea of substantive homogeneity, which he deliberately opposes to the liberal idea of formal equality before the law. The point of law is to act as an instrument of vision of the people, which will be articulated by the executive, and which forms a bond between at least a certain group of the people and the executive. In 1929, Schmitt penned an essay called The Guardian of the Constitution, in which he argued that in moments of crisis following on from the claim in political theology, the executive is the true guardian of the Constitution, and it's Schmitt who comes up with the idea of the unitary executive, which is linked to an understanding of the political people that I think is one of the worrying phenomena in our politics today. Because the problem that Schmitt points us to, and this is the problem that I think comes out of that quote from Cartwright's dissent in Roncarelli and Duplessis, is that while in a rule of law order, we like to think that the law is in charge of the officials, it's still the case that the officials are going to be in some significant way in charge of the law. And we see this problem exemplified in the office of the Attorney General, the main law officer. Someone has to make decisions about the law. And if the locus of those decisions in moments of crisis or in moments of exception is in the executive, then it doesn't really seem that there can be any rule of law limits on what the executive can do. I mentioned a moment ago that Vermeulen is an open follower of Carl Schmitt. But the claim that I want to make isn't that all of the people who have featured in my slides are followers of Carl Schmitt. Nevertheless, it is the case, I think, that what Schmitt shows us better than anyone else is what we can think of as a kind of Schmittian logic, which ties together the idea of a substantive vision of the people, something like the substantive homogeneity of the people, with the thought that in order to put in place that substantive homogeneity and to maintain it, we have to understand that the executive is the true guardian of the Constitution. And for those of you who are interested in reading more about this kind of idea, there are two pieces that you can find easily on the internet. The first is a recent piece by Tamsin Shaw, a political theory professor in the New York Review of Books, which is about William Barr. And as you can see from the title is William Barr, the Carl Schmitt of our time. And what she does in this piece is trace out the links between the kinds of arguments that Barr has been making about law in the United States of America, as well as about the place of religion in the constitutional order and the ideas that Schmitt put forward all those years ago. The second piece that I thought I would point you to is a piece by Thomas Poole, again, easily available online, this time in the London Review of Books, which is called The Executive Power Project. And in this piece, Poole argues that whether or not Finnis and those around him have ever read Schmitt, the arguments that they've been making, which seek to put in place the executive as the center of the constitutional order, are arguments that follow a Schmittian logic, which is why in this piece he, I think, quite powerfully renames what was called the Judicial Power Project, the Executive Power Project. If you want even more reading, I'm now going to suggest some things that I've written recently. One is a piece which I've called Schmitten in the USA. It appears on a German website called Verfassungsblog. And the piece is about Vermeulen and Schmitt. It's a reaction to the piece that appeared in the Atlantic about illiberal legalism. And I try to show there, which isn't very difficult to do, the links between Schmitt and Vermeulen. The second piece, which will appear next week in another online journal, Aeon magazine, is called How Legal Arguments Help Propel the Strongman Leader to Power. And that is a piece about Schmitt and Finnis and the Brexit project. But what I wanted, which is a little like blowing one's own horn, to do is to read to you, and this is going to be my second reference to the COVID issue, the last few lines from the piece Schmitten in the USA. So talking about Vermeulen's intervention in US constitutional debates in the Atlantic, I say right at the end, we will at some point surface from the current public health crisis. How and when and what the new normal will look like, no one knows, but we do know that autocrats around the world are using the epidemic as a pretext to gather ever more power unto themselves. In this light, the fact that a Harvard law professor has published an article at this time with this kind of viral load in the pages of a respectable journal is perhaps more scary than the virus itself. And you'll recall that at the beginning of my talk, I said that it might be in some ways a relief not to spend the time that I have talking about COVID, but that I was going to talk about something that was equally depressing and maybe even more depressing. And the point of this quotation from my own work is that I do have a great deal of confidence, it might be misplaced and I don't know how things are going to pan out, that we will with time emerge from the current public health crisis. There are even those who suppose that we could emerge stronger from the public health crisis than we were before. And I say, frankly, that what that new normal will look like, no one knows. well, my real worry at the moment is not so much as epidemic worrying as it is, but that while the epidemic is going on, autocrats around the world, and I would count Trump in their company, are using the epidemic as a pretext to gather ever more power unto themselves. And what I find particularly troubling as a legal academic at the University of Toronto Law School, is that at law schools, which we regard as our fellow law schools and often as models for our law school, for example, Harvard and Oxford, there are people making arguments which will assist those autocrats to gather even more power unto themselves. I think I'm now getting to the point where I've talked for long enough, so maybe what I'll do is close with what I think is my last slide, because one of the questions that I think naturally arises after a talk like the one I have just delivered is what guarantees are there? If we look to the Schmittian argument, that in moments of crisis, we will find that the executive is the guardian of the Constitution and so at the center of our constitutional order. And we see how lawyers can very effectively make those arguments to courts, arguments that issue in the conclusion that the judges should defer to the executive. Then in what way can we hold out any hope that law can protect us in these moments? And in a real way, I don't think that law can protect us. I think when push comes to shove, the only protection that we have is ourselves. And that's why I thought I would close with this very last slide, which is a slide from a speech given by the great judge who had the great name Learned Hand in 1944 in Central Park on a day called I'm an American Day. This was at a bad time during the war. And Hand is musing about liberty and what protects liberty. And he says in this quotation, "What do we mean when we say that first of all we seek liberty? I often wonder whether we do not rest our hopes too much upon constitutions, upon laws, and upon courts. These are false hopes, believe me. These are false hopes. Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can save it. No constitution, no law, no court can even do much to help it. While it lies there, it needs no constitution, no law, no court to save it." Thank you very much. I'm now ready to take whatever questions there may be.
Hi, it's Raquel from the law school here, from the advancement team. So the first question we have is, can you comment if this illiberal legalism, as it aligns with the memo that provides that the sitting president cannot be charged with a crime? The memo or convention seems to be against democratic principles, the basic rule of law.
Can you read the first couple of sentences for me? Because I lost, I think, the second one there.
I think it's pertaining to impeachment. So can you comment if this illiberal legalism, as it aligns with the memo that provides that a sitting president cannot be charged with a crime?
This is a problem that pertains particularly to presidential systems. And the solution to that problem is, in the end, I regret, a political solution, that is impeachment. And of course, it might seem that what we had in the Senate was not a judicial proceeding, but a bunch of politicians arguing along partisan lines. But I think that in a way, the quotation from Learned Hand with which I ended provides the best answer to that question. I mentioned earlier the idea that we want, if we want the rule of law, to have the law in charge of the officials, but that our problem is that officials are also in charge of the law. And because of the kind of paradox that pairing those two ideas together creates, that the officials are in charge of the law as well as the law being in charge of the officials. In the end, our only hope for the rule of law is if the officials themselves have in their hearts the love of liberty and the rule of law. And I think that what the impeachment issue showed in the United States of America is that, with one exception, Republican senators were not willing to manifest that love of liberty and that regard for the rule of law. And if that kind of attitude prevails, then all bets are off. No law, no court, as Learned Hand told us, can save us.
Okay, so second question is, since the Charter of Rights permits the review of legislation and executive action, is the risk of emergence of a liberal democracy in Canada significantly reduced?
I think it is significantly reduced, but I regret that I'm going to answer that with a version of what I just said. Hungary in the 1990s was part of a giant constitutional experiment as countries moved away from authoritarian rule, in Hungary's case, from communism. In the case of my home country, South Africa, away from the racist rule of apartheid. And Hungary put in place a written constitution with a great Bill of Rights and a constitutional court, which at one point had the world's attention because of the boldness of that court's judgments. So for some time, Hungary was a thriving constitutional democracy. When Orbán came to power, he started chipping away at the constitutional protections, working with judicial appointments in such a way that eventually he ended up with a court that would do his bidding, but getting a majority which allowed him to amend the constitution, and getting to the point now where he can claim that everything he's doing is perfectly legal and constitutional, because everything he has been done in accordance with the law, including the law of the Constitution. So as robust as the Canadian Charter of Rights and Freedoms is, I think it's no more robust than Canadian political and legal culture. And I think what prevents us from going down this path of illiberal democracy is not the Charter of Rights and Freedoms itself, but the fact that for now, and I would hope into the future, Canadians will still step up when they can see that the political and legal culture of the rule of law is in danger.
Okay, third question. How can we prevent these autocrats from holding power in the executive? Political movement response, such as grassroots movements, question mark?
I do think that, and this again, and I'm sure this is the reason why I decided to end with Learned Hand, plays off the sentiments in this slide that stood up. When Trump issued his first travel orders early on in his presidency, ordinary Americans flocked to the airports as a kind of protest against what they saw as an executive order that flouted their understanding of America's constitutional and legal ideals. And that had, I think, had a tremendous impact, maybe more impact than the various judgments, which until the matter got to the Supreme Court, prevented Trump from implementing his executive orders. And so it will be the case that it's political movements that seek to maintain our constitutional values and our rule of law values that will prevent a country from sliding down the path of illiberal democracy and prevent the executive from usurping a constitutional role which in a liberal democracy under the rule of law does not belong to the executive.
Okay, the next question is, does an attempt to lift the parliamentary oversight for 2 years because of COVID-19 reflect a thinking of illiberal legalism?
I do think that even this liberal federal government in Canada was tempted during the first part of the COVID crisis to grab rather more power than it needed in order to respond to the crisis. But that attempt, I think, was largely fought off by the opposition. But I in no way want to suggest that Canadians should be completely sanguine about what's happening in Canada, because there is a tendency in all political orders, no matter how liberal and democratic they are, to try to use a crisis in order to gather more power.
Okay. Lots of questions here. Sorry, I'm just filtering through. One problem which arises out of this topic relates to the appointment of judges by politicians. Are there alternative models for the appointment of judges that do not give politicians control of judicial appointments?
I think it is possible to try to enhance the independence of the appointment process. But I think there the same problem arises as arises with the constitutional independence of the Attorney General. If one looks at the SNC-Lavalin affair, and I should mention that in this course that I mentioned earlier, the Trump, the rule of law and illiberal democracy that I've taught now twice to first-year Toronto students in small classes, we ended up spending almost half the class both times on SNC-Lavalin, just because I thought one shouldn't neglect what seemed to be a Canadian constitutional crisis when it came to the rule of law in talking about Trump and places like Hungary. Well, if one looks at the McClellan report, which was written by Anne McClellan as a result of the SNC-Lavalin affair, she, I think, quite convincingly argues in that report that there is no surefire way of safeguarding the independence of the Attorney General. There are all sorts of measures one can take that will help to maintain the independence of that office. But in the end, and here again I return to learned hand, it all depends on political and legal culture. And I think one can say exactly the same thing about the judicial appointments process. In the country I come from, South Africa, during the apartheid era, judges were appointed as they are appointed in Canada by the cabinet, by the prime minister. And for the most part in South Africa, the judges who were appointed during the apartheid era were judges that whom the government knew it could trust not to rock the government boat. And when the new constitution was put together in the 1990s, as a result of that experience, an independent commission was established for the appointment of judges. And one found much the same kind of process at play in countries like Poland and Hungary. In light of the experience of the authoritarian past, it was thought very important to make the appointment of judges as independent as possible of politics, and to put in place a body that could appoint judges purely on the basis of merit. But in all of those countries, including South Africa until the election of Cyril Ramaphosa in the last couple of years, governments have found it fairly easy to subvert the independence of these independent, supposedly independent commissions. And that is again because the kind of cultural commitment to independence was lacking. Now in Canada, I think that with certain exceptions under the prime ministership of Stephen Harper, especially in the last few years of his of his government. Despite the fact that we don't have an independent process, it is generally held to be the case, and I actually believe it to be the case, that Canadian judges are appointed on the basis of merit. And we have, to a large extent, managed to avoid the kind of politicization of judicial appointments that we see in other countries. And that is with a system where appointment is political. So I think that there are all sorts of things one can do to assist the independence of this process, but none of those things will provide one with any guarantee of that independence.
Great. Okay, so we just have about 5 minutes left, so I'm going to ask 2 more questions. We might go like a couple of minutes over, but we'll try to keep within the time frame. So the second last question is, do you have a view on U.S. voting rights issues and whether laws are being used to suppress the vote? For example, voter ID, limited voting hours, etc., versus the charge the other way, that making voting more accessible, including mail invites, abuse the extra vote.
Well, what I know about that is probably less than the person who asked the question, and this is a very controversial issue in the United States of America. So it seems to be the case, for example, that during the current health crisis, that if voting were done by mail, that this would advantage Democrats. And if voting has to be done in person, with a few exceptions, that will advantage Republicans. And there one can find many other manifestations of this kind of issue. So people tend to break down in according to partisan lines when it comes to discussing this kind of issue. But I will say that there is in the United States a history of voter suppression on the part of particularly southern states that is very troubling, and which looks like it will continue into the next election.
Okay, and then next question is, Carl Schmitt talked about how issues go political. Could the COVID crisis be the catalyst for Trumpian dominance over the rule of law, the act of illiberalism?
I think that without the COVID crisis, Trump was already well on the road to achieving some kind of independence of meaningful legal constraints. Will the COVID crisis make it easier for him to depart from the rule of law? I'm not sure. It might make it more difficult, because I think that if one thinks, as I think, that his attempts to respond to the public health crisis are showing to people in a way that previous episodes did not show, that the faults in the way that he holds his office and the faults in those around him, that this might actually be helpful when it comes to the long-term future of the rule of law in the United States, but I would make no prediction about this.
Okay, I think you can actually squeeze in one more. So does decentralization, for example, federalism, reduce the risk of illiberalism / the threats to the rule of law?
I'm not sure that I have a good answer to that question. Take, for example, our current situation in Canada. The federal government has not invoked the Emergency Powers Act that it has at its disposal, and has left it up to the provinces to deal with the situation in their territories as they see fit. And one might think that this is better for the rule of law than the federal government taking control over provincial matters, and control that it would be unwilling to relinquish once the crisis starts to pass. So I think that it's unclear whether federalism helps or hinders the rule of law in this kind of situation. I noticed that in Wisconsin, a court has ruled that the measures taken by the governor are beyond the limits of his legal authority in responding to the crisis. This measure was prompted by the Wisconsin legislature, where Republicans have a majority. And so here one could say that what we have is a court upholding the rule of law, because it has given a judgment which says that the chief executive officer in that state has strayed beyond the legal limits of his authority. But I think the situation's a lot more complex than that. So I don't think there's an easy answer to that question.
Great. Okay, so that we're just going to wrap up now. So David, just on behalf of the Advancement Office, I just wanted to thank you so much for this informative presentation, and thank you to all the alumni and friends that participated and everyone that asked the question. Following the webinar, likely by tomorrow, I'll be sending a follow-up note with the recording of this webinar and the slideshow. And thank you again, David, and I hope everyone has a wonderful afternoon.
Well, thank you all very much.
Thank you.